All right, good afternoon, everybody, and welcome. Thanks for joining us on a very, very busy day. A lot of programming going on at the law school. Glad you chose this one. My name is Joseph Blocher. I am, along with Daryl Miller, the co-director of the Center for Firearms Law here at Duke. Daryl and I work very closely with Jake Charles, our executive director, to try to deepen and broaden the scholarly conversation about firearms, about gun regulation, about the Second Amendment, but also about other areas of law which intersect with guns and gun regulation. And one of the things that we try to do is try to show that the discussion can be and should be and has to be more interesting than just are you for or against guns. The discussion has progressed certainly farther than the question central in Heller about whether the Second Amendment is about the organized militia or maybe includes more than that. And today's panel, I think, is a perfect encapsulation of just how much richer and more interesting that discussion can be. The main focus of the gun debate often in public is about the constitutionality of certain real or proposed regulations, whether they comply with the Second Amendment or not. But actually, a lot of the main players in the sort of larger ecosystem of guns and their availability are private actors, whether that's gun manufacturers, gun sellers, tort plaintiffs, tort defendants. The lawsuits and litigation and sort of private regulation involved there is in many ways a more important determinant of what guns are available and to whom. And they raise different kinds of legal questions than constitutional questions. They involve questions about product liability or Section 230 of the Communications Decency Act. And we have today a fantastic panel to help us think through some of those questions. Beginning at the far right, we have Professor Mary Ann Franks, who is Professor of Law and Dean's Distinguished Scholar at the University of Miami. On top of that, she is also President and Legislative and Tech Policy Director of the Cyber Civil Rights Initiative, which is a nonprofit organization dedicated to combating online abuse and discrimination. Of note, Professor Franks drafted in 2013 the first model legislation to criminalize, or criminal statute rather, on non-consensual pornography, sometimes referred to as revenge porn, which has been this model statute that Professor Franks drafted, has been followed as a model in many states and even in proposed federal legislation. She is also the author of The Cult of the Constitution, which I commend to all of you, Chapter 2 in particular, which deals with guns. This actually needs a new sticker, I noticed, because last week the American Association of Publishers gave it the 2020 Prose Award for Legal Studies, so congratulations to Professor Franks for that. After Professor Franks, we'll hear from Professor Tim Lytton, who is the Associate Dean for Research and Faculty Development, Distinguished University Professor, and Professor of Law at Georgia State. His scholarship, broadly speaking, examines health and safety regulation with a focus on gun violence, clergy sexual abuse, and food policy. He has a sort of general interest in how public policy, the public policy implications of tort litigation. His most recent book, which is appropriately but somewhat ominously named Outbreak, given what we are facing maybe in the news right now, but deals with actually foodborne illness and the struggle for food safety. But for our purposes today, the book that may be more relevant is this one, for which he's responsible, Suing the Gun Industry, which, as its subtitle says, describes the battle at the crossroads of gun control and mass torts. And then finally, we'll be hearing from someone who was a part of that battle. Kal Burton is a partner in the Chicago offices of Steptoe and Johnston, who was deeply involved in the sort of wave of litigation, sort of, I guess, the last major wave of litigation involving the gun industry. He, throughout his 30-year career, has defended and won many complex toxic tort and product liability cases, and most relevant for our purposes, he was for 25 years counsel to, I'll just say, a major, well-known firearms company, which I think he'll talk about in his comments, defending against a broad range of product liability claims all across the country. It was counsel at trial in Texas, Alaska, California, Connecticut, Tennessee, other states as well. We're going to leave lots of time for questions at the end, so please have them prepared. And with that, I will turn it over to Professor Franks.
Thanks very much, and I'm really happy to be here. And my focus is going to be on what I've been calling private sector regulation of guns. So as Joseph was saying, the conversation is so much broader now than it used to be. For a long time, it seemed as though there's just a legislative stalemate when it comes to gun regulation. And while that has changed and shifted a little bit since the Parkland shooting in 2018, a lot of what we've seen in terms of the movement on gun regulation is actually coming from the private sector. So not actually in terms of legislation, but in terms of policies by private actors, which raises, I think, some reasons both for optimism and maybe also some continued pessimism. What I'm thinking of in particular, as I'm sure many of you know, is that many major retail stores in the wake of the Parkland shooting decided that they were going to change some of their policies around the sale of firearms. So you had Dick's Sporting Goods and Walmart and many other major retail stores saying they would no longer sell certain types of assault-style rifles and that they would impose age restrictions on gun purchasers that were not required by law. And so Dick's Sporting Goods in particular also reiterated their ban on selling bump stocks. They announced their plans to destroy all of their unsold assault-style weapons in their stock to ensure that those weapons would never enter the marketplace. We also saw that Walmart and several other stores were also going to no longer sell to customers who were below the age of 21. And we also saw that many of these stores in the last few months, especially following the mass shootings at a Walmart in El Paso, that many of these stores have now at least imposed some kind of soft policies against open carry of weapons in their stores, and that has caused some controversy as well. We also saw that there were banks that were intervening against some of the practices that had been considered standard for some time. For instance, Citigroup became the first bank in 2018 to take a stance in the nationwide gun control debate by imposing a new policy that would compel existing clients to enforce background check requirements and abide by an increased age restriction of 21 years old when selling firearms, and also bans retailers from selling bump stocks and high-capacity magazines. And soon after, Bank of America followed and also said that they were no longer going to be financing the gun manufacturing industry as they had before. Colt even said that it was going to stop manufacturing AR-15s, and we also saw that there was a discontinuation on the part of many companies for their NRA discount policies, which many people didn't know existed to begin with, but Delta, United Airlines, Hertz, Enterprise, Avis, several hotel brands announced that they would no longer be honoring their NRA discount memberships. So it's interesting to think about what the impact of all this has been. That is to say, to the extent that we're seeing the gun regulation debate move out of legislators' hands and maybe more to the private sector, it is interesting to first think about the response that that has generated and to think about how and whether this actually moves the gun control debate in the United States forward. So one of the things that's interesting about the response, as you might imagine from the National Rifle Association and from some other conservatives who identify as Second Amendment advocates, is that the response has been extremely negative. There has been impact not only in terms of the lobbying arms that are making statements about how they think these policy changes are bad and how they in some ways infringe upon Second Amendment rights, but there's also been litigation over some of these policies, and there's also been other forms of, if you want to say, retaliation as a legislative matter against some of these private actors that have taken this stance. So, for instance, there are several gun rights organizations that has condemned what the banking industry has done, in particular by saying this is a backhanded way of undermining the Second Amendment, finding that these steps are threatening the firearms industry, and that they announced that they may seek protections from Congress to prevent financial retaliation from banks. The NRA, through its lobbying group, the Institute for Legislative Action, has said that banks are interfering with their constitutional rights. The National Shooting Sports Foundation has asked lawmakers to stop the banks from acting on this issue. And some state lawmakers have also entered the fray. In August 2018, the Louisiana Bond Commission voted to exclude Bank of America and Citigroup from bidding on underwriting the sale of $600 million in bonds for the financing of interstate improvement and tunnel replacements. And some of you may remember, too, there were threats on the part of Georgia lawmakers against Delta after Delta ended its NRA discount program, a program that 11 people had taken advantage of up until that point. Threatened to deny them a tax break that would have given them millions of dollars. And eventually, eventually that threat was found to be empty, but that was a standing threat for some time from the lawmakers in Georgia. And if you look at the NRA's response in terms of the ideological response to what is happening, the NRA issued a statement in response to Walmart in particular, because that seemed to be the company that was generating the most attention. The NRA wrote in response to the new policy against open carry that the strongest defense of freedom has always been our free market economy. It's shameful to see Walmart succumb to the pressure of anti-gun elites. Lines at Walmart will soon be replaced by lines at other retailers who are more supportive of America's fundamental freedoms. One of the reasons why this is interesting, and in addition to the policy, or if we might want to say the kind of response in a more casual way or a more sense of a commentary as to whether or not these policies are wise or not, we've also seen litigation in response to those stores that have decided that they're not going to sell certain types of firearms to people under the age of 21. In Oregon and Michigan, which happen to be states that include age as a protected class in their public accommodation statutes, suits have been brought against Walmart and Dick's Sporting Goods on the grounds that they are violating anti-discrimination statutes. Those haven't gotten very far. There were settlements in the Walmart case and also in the Dick's Sporting Goods case so far. So in other words, the response has been negative from those who consider the debate over guns to be a constitutional debate in every sense. And there, of course, is some, if not irony, there's something quite interesting about the way that backlash has worked. That is, first of all, that conservatives, broadly speaking, have historically been very supportive of the free market, have been very supportive of the private sector taking a moral stance on issues of the day. And so we see much grassroots support, for instance, for Chick-fil-A, even though it was revealed that their management has some peculiar notions, let's say, about homosexuality or about their Christian beliefs. If we look at Masterpiece Cake Shop, of course, the case that essentially argues that a baker has got a First Amendment right and a religious expression right not to bake a cake to celebrate a same-sex wedding. If we look at the ongoing case of Bostock and the other related cases about whether or not one can discriminate against transgender individuals, et cetera, the general line from the conservatives tends to be, this is all good, right? Because this is private sector intervention. These private companies can take whatever moral stance that they would like, and therefore we should be celebrating the fact that, you can let 1,000 flowers bloom when it comes to these kinds of issues. But when it comes to the Second Amendment issues, it seems that there's a very different tune that is starting to be sung, which is a sudden recognition on the part of conservatives that maybe the free market is not so free, and complaints about the fact that the private actors that are doing this kind of innovation or taking these kinds of stances are not only doing something incorrect and immoral, but they are doing something unconstitutional. In many interesting ways, and I hope that we'll be able to get to this in the Q&A, this debate or this conversation parallels a very similar conversation around Section 230 and the question about whether or not social media companies have obligations to honor the First Amendment rights of citizens. So you may have heard that it has become quite a popular thing now for conservative lawmakers to support innovations against Section 230, that is to say the law that protects most tech companies from any kind of liability for the kinds of things that gets posted on their sites or use of their services, that for a long time the free marketers among us, and that would include both conservatives and civil libertarians and others, were enthusiastic about this very, very broad protection because supposedly it fosters private industry and it helps the market and all of the rest. But in the last few years, Republican lawmakers in particular have argued that conservative viewpoints are being suppressed on Twitter and on Facebook and other places, and therefore we should support litigation against these particular companies and maybe also legislatively roll back that particular immunity that has been given to these companies. And so many of you may have become aware of the fact that there was a recent litigation over Prager University, which got slapped down a short time ago about this exact question, about whether or not Twitter has any First Amendment responsibilities here. There was an op-ed in the Washington Post by Charlie Kirk, who is the head of the Turning Point USA, who then says, who writes an editorial about how we need to take a different perspective on these private companies in the tech industry because we've realized, even though conservatives generally favor the market is no longer free. As Kirk says, the free market must be functioning freely for this to be true. There's ample reason to believe that now the market's normal corrective powers are being blocked by anti-competitive forces. So suddenly conservatives have developed a conscience about whether or not the economics that underlie our free market system are actually accurate. Now, how much of this is in good faith and how much of this is just a calculated political ploy, we suppose we can have a conversation about this. But one of the things I think as a policy matter is quite disturbing is that we are seeing that, at least on one read of this is essentially a certain demographic or a certain conservative portion of the population that essentially does not care about either the rule of law or about legal principles, except to the extent that they benefit them. That is what I'm reminded of as I see the response to that conservatives are having both against, let's say, the supposed suppression on Twitter and the supposed violation of First Amendment rights, and what we're seeing in this debate over private companies developing their own policies about guns. We are seeing a kind of instantiation of something that was laid bare in 2016 when Donald Trump was running for president, when he was asked in October 2016, will you respect the results of this election? And his response was, I will respect it if I win. And I am afraid that what we're actually seeing laid bare right now is exactly the masks coming off about how there is no principle, whether it is the free market or the Constitution or any other policy, that actually matters to the people who happen to be in power, except that they should win. Now, is that going to be the end of the story? Are we going to defeat private sector regulation in the same way that legislative responses have been stonewalled? The chances are that maybe there's going to be really a moment for innovation in this space because, after all, it is not going to be correct. It is certainly not correct that these private companies have a Second Amendment obligation. They don't have a Second Amendment obligation in exactly the same way that Twitter does not have a First Amendment obligation, and the courts have been pretty steady in saying as much. That, of course, the First Amendment and the Second Amendment and all of our constitutional rights are really subject to the state action doctrine, and that isn't just a restriction in a kind of narrow sense of saying that's why that's not appropriate for these conversations. It's a longer and more interesting sort of substantive defense of the sphere of individual freedom that these private actors have to set any kind of policies they want. So, for instance, we saw as a kind of reaffirmation of this in a case recently called Manhattan Community versus Halleck. You had the majority opinion reasserting the fact that this is the state action doctrine isn't just a kind of forgettable restraint. What it is a protection of the sphere of individual liberty, that we should respect the fact that anyone who is not a state actor, and we should perceive the state action doctrine as extremely narrow, anyone who is not a state actor has the right, affirmative right, to engage in this process of liberty for themselves to determine what kind of speech they want to carry, and for that matter, we could say by extension, what kind of firearms they do or do not want to carry. So in that sense, it may be good to have this worked out because one of the powerful ideological impulses that the NRA has been able to capitalize on for decades has been this fuzziness around the Second Amendment, the idea that everything that relates to guns is somehow about your constitutional rights. It has been one of the most powerful and most successful propaganda campaigns that has gone on for decades, the idea that you're not allowed to touch guns unless you want to essentially say you hate the Constitution and don't want to be an American anymore. So to see the private corporations actually standing up for this, somewhat ironic, right? Because one of the reasons why we got to legislative stonewalling on the gun control issue was because the NRA as a corporation was so powerful that some of this corporate influence actually being used in the opposite direction is certainly, I think, in some very cautious way, probably a good thing. We may also want to think about the fact that even though you've got a decision in Heller that says you have the right to have a firearm in your home for self-defense, pretty much all the rest of the time that we spend outside of our homes will be in someone else's private property. That increasingly, for better or for worse, most property is now privatized. There's been some really interesting work by Cody Jacobs on premises liability and the idea that essentially all kinds of spaces where we spend a lot of our time could be subject to a kind of theory of liability, which would encourage them to actually have anti-gun policies, because in the absence of those, they could be seen as negligent with regard to the accidents and the intentional crimes that happen when people are allowed to have their guns freely. So it is at the minimum, there is a real challenge now to the kind of ideological stranglehold that the NRA has had, and that might be a good thing. If we think about some previous examples of the private sector getting involved in social issues, one of the things that comes to mind for me is that in the late 1800s, that Sears Roebuck decided to send their catalogs or make their catalogs accessible not only to poor whites but also to Black Americans, which transformed in some ways the ability of Black Americans to clothe themselves and also to attain a certain level of respectability, and actually did a lot in some sense for racial progress in the United States, and it was purely an action by a private company. that we may be seeing some parallels here, that even if this doesn't necessarily cash out legislatively, it may not necessarily have to, that the battle for hearts and minds might actually change something about the way that people perceive the firearms issue, and may be clearer to actually get out into the open this kind of fuzziness that the NRA, again, and the gun lobby has been trying to promote for many years, which is that every gun issue is a self-defense issue, is a constitutional issue. The idea that we would have this competing narrative that says, actually, an important act of liberty and an important act of freedom and self-determination and autonomy is to say, I don't want guns here. I don't want to sell guns to you. I don't want these types of guns to exist at all. That there would be powerful corporate actors in addition to private individuals who are able to make that claim is at least, I think, some reason for cautious optimism.
Thanks so much, Joseph, for the opportunity to be here. I'm delighted to be here at Duke to share some thoughts about background history of lawsuits against the gun industry for gun violence and where we are today in terms of this type of litigation. Let me begin with a little bit of background. Starting in the late 1980s, gun violence victims started to bring lawsuits against not only the people who shot them, but also the people who sold the weapons that were used to injure them. And these early suits, the earliest suits, were against retailers, and there were a series of suits that were successful, or a handful of suits that were successful, and the claims were of the following form. Purchaser comes into store, says to clerk he wants to buy a weapon. He's visibly deranged. He says he wants to use the weapon to shoot girlfriend. He buys weapon. It's sold to him by the clerk. He takes the weapon. He goes into the parking lot. He shoots the girlfriend. There's a victorious verdict in favor of the plaintiff. The plaintiffs won a handful of these cases, and on the heels of those victories, a number of plaintiffs' lawyers started to bring lawsuits not just against the retail sellers of the weapons, but against the manufacturers of the weapons. And these lawsuits were brought around the country in both state and federal courts, and these began also in the late 1980s. And alongside these, a number of municipalities started to bring lawsuits against the gun industry, and there was a rise of government entity lawsuits against gun industry players, both retailers and manufacturers. These sort of crested in the early 2000s, late 1990s, with about 30 lawsuits by municipalities and a large array of different individual lawsuits against both retail sellers and manufacturers. I want to focus for a moment on the manufacturer suits. The manufacturer suits were brought under a number of different types of theories. There were some lawsuits against manufacturers under theories related to strict liability, the idea that the risks associated with certain firearms designs outweighed their utility. There were also a variety of different negligence claims brought against manufacturers. Some of them were for negligent oversupply, the idea of selling more weapons than a company knew the legal market could bear. Other negligence theories included overpromotion, selling weapons in ways that might increase the risk of their misuse in crimes. And finally, failure to supervise downstream retail dealers. There were trace statistics out of the Bureau of Alcohol, Tobacco, and Firearms and Explosives that suggested there were certain retailers who were sort of hotspots for illegal sales, and the argument was it was negligent for manufacturers not to be policing their supply chain downstream. Finally, there were a number of theories brought under a general public nuisance approach, this idea that public nuisance generally says that a defendant is liable for anything that would damage public health or safety or rights that are generally accrued to the public. And just like you might sue a polluter for industrial waste in streams or for smokestack pollution in the air, there were lawsuits brought against manufacturers for sort of pumping out weapons into the larger society. Starting in around 2003, there was a movement by the industry and by the NRA to secure immunity from these lawsuits. And this was a relatively successful movement. 32 states passed laws that granted the industry immunity. And in 2005, Congress passed a law called the Protection of Lawful Commerce in Arms Act, which granted the industry immunity from suit for any kind of injury arising out of the criminal misuse of the weapon. Interesting to keep in mind is that even as these legislative victories were accruing, it should be noted that not a single plaintiff in a lawsuit against a manufacturer for any of these theories ever obtained a favorable judgment or a settlement in any of these cases. So the immunity bill was really brought not so much in response to victories by plaintiffs, because the industry prevailed in all of these cases, but instead to really stop the tide of litigation or the continuing litigation costs that this was causing the industry. So the question that I wanted to focus on more centrally today is, where are we in the post-Protection of Lawful Commerce in Arms Act, or PLACA era? And I think where we are is that most of this litigation really dried up to a trickle following 2005 when Congress passed this law. But since then, there has been some activity on the litigation front. There have been lawsuits in really three types of venues. One is against retail sellers. There have been lawsuits against manufacturers, and there have been lawsuits against venues where mass shootings occur. The one successful lawsuit that has come along recently was a 2005 lawsuit against a gun retailer, the Badger Gun Store in Milwaukee, Wisconsin. In that case, 21-year-old walked into a gun store with 18-year-old. 21-year-old was legally entitled to purchase a weapon. 18-year-old was not legally entitled to purchase a weapon. 18-year-old points out the weapons of interest. 21-year-old takes them or asks the clerk to take them off the shelf. 21-year-old then proceeds to purchase the weapon that the 18-year-old indicated the 18-year-old wanted. When 21-year-old puts down on the federal firearms form that the 18-year-old is the intended user of the weapon, he's told by the clerk to correct that. He corrects that and puts the 21-year-old's name in, and the firearm is sold. It showed up 2 weeks later in a shooting by the 18-year-old who shot 2 police officers in the face with the weapon. This was not a particularly difficult case to bring, and it was brought in Milwaukee. The plaintiff secured a victory in this case. Among the evidence that was brought at trial, the owner of the store said that the sale had red flags all over it, and it was brought under 2 theories that are exceptions to the PLCAA statute. And one of those exceptions is for negligent marketing, any type of negligent sale of the weapon to a person who is manifesting some increased risk of criminal misuse of the weapon, or an illegal sale, that is the sale of a weapon in violation of a state or federal firearms license that is applicable to the sale of the weapon. The jury returned a verdict for $5.7 million for the police officers in this case. The case was appealed, and before the appeal was heard, it was settled for $1 million. Moving on to the second area or front in litigation against manufacturers, there are a series of cases currently in litigation around the country against manufacturers, the most famous of which is grown out of the Sandy Hook mass shooting in Newtown, Connecticut. And in that case, the Supreme Court of Connecticut has allowed this case to go forward under PLCAA under the exception for violation of a firearm statute applicable to the sale of the weapon. And that firearm statute, according to the plaintiffs in that case, is the Connecticut Unfair Trade Practices Act. Now, a number of these types of lawsuits have been brought in other places, and both the Second and the Ninth Circuits rejected this idea that a general consumer protection law could be used as an exception to PLCAA, and that in fact the PLCAA exception is for violation of a firearms statute that is applicable to the sale of a weapon, meaning designed to regulate the sale of firearms specifically, and not generally some sort of consumer protection statute. The Connecticut Supreme Court has read its own statute differently and has allowed the case to go on into discovery. That case is currently being tried in Newtown, Connecticut in state court. There also is a weapons design claim against the manufacturer of the weapon that was used in the Las Vegas shooting, and the argument in that claim is that the AR-15 platform is so easily modifiable into a fully automatic platform that it is tantamount to selling an illegal machine gun or an illegal fully automatic weapon, and that would be in violation of a federal firearm statute. What the future of those two cases is unclear. My guess is that either one of them, if they were to survive trial and move on and survive state appeals, is likely to be headed for the Supreme Court. Finally, there's a third front in this sort of new wave or current wave of post-PLCAA litigation, and that's premises liability cases. There was a successful case brought against the MGM Hotel growing out of the Las Vegas mass shooting, and in that case, the MGM settled. MGM and its insurers agreed to pay $800 million in settlement to the many victims in that case. There has been of note also the opportunity for backlash against these cases in the following sense. Many of the state lawsuits have provisions that provide anybody who brings a suit that is unsuccessful in the face of one of these immunity bills can be subject to court fees and costs. And in fact, in the Aurora shooting case, plaintiffs brought lawsuits against the manufacturers of ammunition, and the ammunition manufacturers prevailed, and then they brought lawsuits for fees and costs against the plaintiffs in those suits, and those lawsuits were successful. I think it's fair to point out that there's a lot of focus in the media when we talk about these lawsuits about win-loss ratios, and the fact of the matter is, before the immunity bill, plaintiffs never prevailed in lawsuits against manufacturers, and with the exception of the current lawsuits in Sandy Hook, there's very little reason to believe that this litigation is likely to produce a lot of verdicts on the plaintiff's side. But I think it's important when you think about the impact that private litigation has in public policy to think beyond just who wins and who loses in court, or whether or not there's a jury verdict or a judgment in favor of the plaintiffs or the defendants. This would be true both in gun litigation, but also in other areas that we've seen where lawsuits have been brought to sort of move the policy needle. Places like clergy sexual abuse or youth organization sexual abuse lawsuits, or food-borne illness lawsuits against food industry players, or tobacco litigation. And I would suggest there are at least three ways to think about the ways in which the litigation process itself, irregardless of who wins, can actually move the policy environment to some degree. One of those is framing, the idea of framing a popular understanding of what the problem is. And gun litigation holds out the possibility of reframing the issue of gun violence away from simply a problem of criminal misuse of weapons towards a focus on what is the role that marketing, design, and promotion and sales and distribution within the industry play within the overall picture of gun violence, and how might we think about supply chain management as a possible way to address gun violence issues. And the reason that happens is because these plaintiffs aren't just bringing lawsuits against the shooters, they're bringing lawsuits against the manufacturers and their distribution practices and their marketing and their design practices. That puts a spotlight on industry practices as a way to think about sources of gun violence that's different, and that reframes the issue as an industry issue and not simply as a criminal misuse issue. Second is information production. The civil discovery process often offers plaintiffs an opportunity to bring out information against industrial defendants that is not available often to regulators. That's been a mixed record in this case. I think with gun litigation, there has been some information that's been brought out in the public about what it is that manufacturers may know about the leakage of weapons into illegal markets, or what they may know about the convertibility of the AR-15 platform. But there's been not an enormous amount of information that's not already available either to regulators or the public. And the final one of these is agenda setting. That is, litigation often puts an issue on the public's agenda through media coverage, and it also puts the issue on public policy agendas of state and federal lawmakers and law enforcement agencies. I would say this is probably the weakest example of the way in which tort litigation often affects public policy in the case of firearms litigation, because it doesn't really take a lot of litigation to put this on the public agenda. Gun violence has been front and center of the public's agenda since the 1960s, and it's really continued in one form or another, whether that's been political assassination, urban gang violence, or now school mass shootings. And so I'm not sure litigation has really moved that needle very much. I think when we look at the ways in which framing, information, and agenda setting are outcomes of private lawsuits that can help move or shape the policy environment, probably the strongest examples of this we see are in tobacco litigation or in clergy sexual abuse litigation, where we've seen an enormous sea change in attitudes of policymakers towards these issues, and we've seen enormous regulatory changes as a result of private litigation, which sort of kick-started the policy process. I think the impact of private litigation in the firearms space has been much lower and far more muted. I'm not sure that all the money that has been spent in the litigation has really produced a lot of change on the public scene. And part of that may be that in some ways, the public policy environment around firearms is almost sui generis. It would seem that in almost any other industry, when there is a major event or outbreak, whether that's the food industry or youth organizations or the Boy Scouts, or the insurance industry with storm damage, when there's a hurricane or there's a major sexual abuse scandal or there's a major foodborne illness outbreak, there's a big shakeup, what political scientists call a focusing event, which tends to shake up people's views about the problem and get a certain amount of movement going in terms of changing policy. And we tend to have sort of a punctuated equilibrium pattern where there's a sort of stalemate in a policy area, and then there's some outbreak or major catastrophe, and things get shaken up, and we see a policy change, and then we settle back in. In firearms, this does not work. In firearms, it's one of the only areas where when there's a massive catastrophe like a mass shooting, people tend to get more solidified in their views. So in northern states where there's more interest or sympathy towards regulation of firearms, we get marginal increases in the regulation of firearms sales, whether that be in increased background checks or limitations of the types of weapons or accessories that can be sold. And in southern states, places where I now live in Georgia, the reaction tends to be the expansion of the right to carry or gun rights in one version or another. So in response to Florida mass shootings in Georgia, there was a lot of policy change, and the policy change resulted in campus carry, where individuals are now able to carry concealed weapons on public university campuses as a response to the concern about widespread private misuse of firearms. So I think that It's unclear what role litigation really does play in this. It's an important litigation phenomenon. I think it's useful to study, but in some ways it has not borne the type of fruit that we've seen from other types of mass tort or nationwide litigation efforts to deal with public health and safety problems. I would just leave open a couple questions, and hopefully this will lead into Kal's remarks, who probably knows more about this than I do. I think that the hope of plaintiffs at this point is that continued litigation will try and raise some awareness and out some new information about the possibilities that might be out there for manufacturers to exercise a little bit more influence downstream in their supply chain. We don't really know the extent to which manufacturers and distributors might be able to provide greater training or supervision of retail dealers to make sure that the bad apples, like the Badger gun stores, are not subject to being part of their supply chain. We might also want to know more about whether or not there are marketing restrictions, voluntary marketing restrictions, that might be used to reduce the risk of criminal misuse of weapons, and whether or not the firearms manufacturer either knows anything about that or whether manufacturers might have levers to make that possible. And finally, there may be questions about product design. There has always been sort of a vilification of certain product designs. In the 1980s, it was small weapons, easily concealable Saturday night specials. Now it's the AR-15 platform. There's a lot of reason to believe that there's a sort of focus on designs that's not very well informed, but it may also be the case that there may be design decisions that the industry does know about that may have an influence on the risk of criminal misuse of weapons, and that would be something that would be useful to know about. I think these are the types of things that people bringing these lawsuits, certainly in the plaintiff's bar, are interested in learning more about and focusing on. We don't have a lot of public health research in this because there was a restriction on the use of government funding for public health research on firearms. That's been lifted now, and I think the hope is that litigation will help move or fuel some of that by framing the issue and keeping it focused on supply chain management and the possibility of industry's role in reducing gun violence risks, marketing restrictions that may be available, and possible product redesigns that could help move this along. Thank you.
Good afternoon. My name's Kal Burton, and I'm not from academia. I've been in a law firm working in law firms for many years. And I'm speaking not on behalf of the industry. I've represented firearms companies through my career. I was national counsel for Smith & Wesson for many years. But I'm here telling stories and tales just from my own experience and my own opinions. When I was asked to come in and talk about civil litigation and how it's impacting the firearms industry, it's always been the position of the firearms industry, and certainly it was what I advocated, is that the courts are not the appropriate place to determine societal issues such as responsibility for the misuse of firearms. That's a legislative question, and in the court cases we handled, we never really got into the constitutional issues too much. It was always just, this is for the legislature, and theories of defect and negligence really don't apply to the misuse of firearms and how guns are distributed. Those issues, how guns are distributed, there's a body of law. They're handled by the federal government, the BATF, by state laws, and it's not for an individual judge sitting in one courthouse or another to get involved in that. Manufacturers are not insurers of their products, and no product, such as a firearm, is incapable of not causing harm. And so it was always our position and my position that the civil litigation is not the place to resolve societal questions such as firearms. Now, I got involved in this back in the early 1980s. I was a clerk at the Seventh Circuit, and the city of Morton Grove passed a law that banned all handguns. And they were one of the first communities to do that. And now Illinois has in their constitution a provision that says, subject to the police powers, the right of individual citizens to keep and bear arms shall not be infringed. So it's more specific than the American Constitution. So a police officer files suit claiming he wants to have a gun in his home, a handgun, and the judge upholds the ordinance. It goes to the Seventh Circuit, and the Seventh Circuit affirms the ruling upholding the ordinance by a 2-to-1 vote. I was asked to work with the judge who wrote the dissent in the case, and the majority opinion held that, well, the ban doesn't ban all guns, it just bans handguns, and you can still have a long gun, a rifle or shotgun, so it doesn't infringe the Constitution. And the Second Amendment doesn't apply to the states, it's federal government, so the majority opinion upheld the ordinance. And the judge that I worked for said, first of all, regulation of firearms is preempted by the distribution system that's been set up by Congress and the state. The state of Illinois has extensive regulations, so does the federal government. It's not for an individual city to overcome that. He also said, I can't go at it on a Second Amendment basis. He said, I'm going to go at him on a privacy basis. A man's home is his castle was the phrase that he used. And he said, just as the courts have recognized the right of privacy, I'm going to recognize it in the home. So that was the argument he had. It was a 2-to-1 decision. It went up to the Supreme Court. They didn't take cert. And so Morton Grove had a regulation that banned handguns. The city of Chicago promptly followed up, as did other communities. The city of Chicago banned all guns. And it was never challenged. So from my clerking days, I went to work at a firm that did some firearms work. And in early 1980s, 1983, the police chief of the chief of police for the city of Chicago was going into a hotel and was gunned down. And so the family hired a lawyer named Phil Corboy to represent them to bring suit against the manufacturers of firearms. And they brought 3 cases. One of them was against Smith & Wesson. Corboy was probably the best plaintiff's attorney in the state of Illinois, if not the country, during those days. And he had a lot of clout, and they brought the case hoping that because of the prominence of the man who had been gunned down, that they would be able to, they challenged the way firearms were distributed in the United States and held that the manufacturers were responsible for not policing the distribution of their guns. So it goes up, we lose in the trial court, it goes up on appeal, and the first district in Chicago, which is based in Chicago, came back and said there's no duty to prevent the sale of guns to persons likely to cause harm. And they said Congress and the states have determined what the distribution network is, and there's no basis to impose liability for negligence. They rejected the negligence claim, saying there's no duty. They rejected the warnings claim, saying, what can you possibly warn against that would have impacted this shooting? Everything that you need to know about a gun is open and obvious, or is contained in the instructions that the companies give. And so they rejected that theory, and they said ultra-hazardous liability doesn't apply either. So those went to the state Supreme Court. They didn't take the case. And so that pretty much was the type of law that we had going back into the 1980s. We had cases around the country where they brought claims for negligence, strict liability, and the courts pretty much uniformly rejected those, particularly against the manufacturers, because it was too remote from the sale to the actual event. And they determined that criminal misuse of firearms is not something that would be deemed foreseeable from product liability purposes. And they said that generally that there's not a proximate cause issue, that the manufacture and sale of the product is not the proximate cause of the event. There's a couple of false premises that were always pushed during those days, during the 80s and 90s. They would argue that the purpose of a gun is to kill someone or to cause harm. That's not true. The industry and the courts accepted that, well, there's a lot of valid uses to firearms. There's hunting and target shooting and defense and sporting purposes. So you can't just say the purpose of a gun is to kill. They said, well, you have to know that your product can be used by criminals. But the companies are putting out and they're complying with the laws that the state and the federal government require. So that's a false pretense. And then finally, there was the argument that, well, if you hold the company liable and enforce the distribution, it'll decrease crime. But then you've got the city of Chicago where they banned guns for years, and we all know that that didn't work out too well for them. So in the mid-90s is when there was the first cracks against the industry. And the case that really got it going was a case out of New York, Hamilton versus KeyTech. And this woman, Lisa Barnes, and she was working with the Brady Center, brought suit against the entire firearms industry and a number of sporting associations, claiming that the way the companies distribute their firearms, they should know and they should police the distribution because they know it's going to get into the hands of criminals and cause harm. And she sued on behalf of a number of individuals whose family members had been shot and killed in shootings in New York. She made allegations that the guns are like a pathogen, it's an epidemic of violence, and that it was negligent marketing on the part of the firearms companies. So the case gets assigned to Judge Jack Weinstein. If you're familiar with judges, federal judges around the country, Judge Weinstein was one of the more prominent judges in America, very innovative thinker, very cutting edge, and he just got into this case big time. And we moved to dismiss. He denied it, and so there was massive discovery of the entire industry, how they distribute their guns, and it ultimately went to jury. He denied, Judge Weinstein probably didn't rule an objection in the defendant's favor in the whole trial, and the plaintiffs won the case. They had verdicts. It was a 4-week trial, and there were 15 findings of negligence, and reduced that, there were special interrogatories to the jury. There was 9 findings of proximate cause, but she was awarded money. And the defendants moved for judgment notwithstanding the verdict, and that was denied by Judge Weinstein. So it went up to the Second Circuit Court of Appeals. They sent the case to the state court, and they said, this is a New York question. And New York came back and said, no duty. There's no duty to enforce the distribution of your products. And second of all, they rejected one of the theories that they put forth, their marketplace liability, and said the theories of marketplace liability like you have for certain pharmaceuticals like DES products, that doesn't apply with firearms because you can find out who fired the gun, the type of gun, if you're lucky enough to have that evidence. But so that case went on for about 4 or 5 years. And during that time, as was discussed just previously, the cities got involved and they started suing the firearms industry. First it was New Orleans, and then the city of Chicago. And by the end of the day, there was 30 cases going where they're all suing a number of different theories, primarily nuisance. And they were coordinated by the cities and by the attorney generals. Andrew Cuomo was quoted as saying it was going to be death by 1,000 cuts. And they knew that they didn't have to win every case, but they were going to bury the defendants in discovery. We had interrogatories and requests to admit and document productions going in 30 cases. And they knew they only needed one case to win. And there's this perception that the industry is this huge multi-trillion-dollar industry. Let me tell you, that is not true. At least it wasn't true in those days, where the industry is not one mass industry. The interests of a firearms company, a manufacturer, is quite different than the associations. And even amongst the associations, their interests are not always aligned. The NRA is concerned with the users of the firearms, the sellers of the firearms, distributors or sellers, and the manufacturers have their own interests. So anyway, with these 30 cases going, the fees and costs and the risks were increasing. I was representing Smith & Wesson during that time, and other people from my firm had other manufacturing clients. And Smith, they decided that enough was enough, and they had a CEO who was not from the gun industry originally. He was from the furniture industry, and he was really concerned with revitalizing the manufacturing process. And so they cut a deal with HUD to put safety locks on their guns, to take steps to enforce their distribution. In return, they were supposed to get priority from various cities and counties in terms of purchasing their pistols and revolvers for their police force. That created a conflict of interest for me and my firm because we were representing other manufacturers in these municipal litigations. And so I resigned, and my firm resigned as counsel for Smith & Wesson at that time. Now, long story short, the agreement, the consent decree, kind of got forgotten about, and about a year or two later, Congress enacted the Protection of Lawful Commerce and Arms Act. That came about, and at the time we were talking about the need for protection, and the analogy was always First Amendment, and we looked at what happened in the South during the 1960s, and what happened was the sheriffs and the police and the people in the South were suing the national media, like the New York Times and Life magazine, for reporting on civil rights battles that were taking place in the South. And if you're in the New York Times and you get sued down in someplace in Alabama for a libel suit back in 1964, I guarantee you were not going to win that case. And they knew that. And so there were multiple lawsuits against the media back in the 60s. And so ultimately the Supreme Court came to the rescue in the Sullivan versus New York Times case with a new standard for libel and slander. So they protected a constitutional right that was there. The gun industry needed something too. The manufacturers needed something too. And in this instance, Congress stepped in with this act and said manufacturers can't be responsible for criminal misuse of their products. And that pretty much took care of all the cases for about a decade. What's interesting is, well, until recently, and in the state of Connecticut out of the Sandy Hook shooting, recently allowed a case to proceed based on a violation of the consumer statute that they have in their state, basically claiming wrongful advertising. And the court has let that proceed. The motions to dismiss were denied. Cert was denied by the Supreme Court just this year. What's interesting is the state of Connecticut Supreme Court just about 10 years before in a nuisance case brought by the city of New Haven, I think it was, said that it's too remote. You can't sue the gun industry and manufacturers for injuries because of distribution. There's not enough nexus there. Now the state Supreme Court allowed it to go through. They're going to have discovery. It's going to be very contentious again. But I predict the same thing that will happen there as happened with the Hamilton case that I had in New York City, that ultimately the state will conclude that you can't make that connection between the distribution. There's First Amendment issues in terms of advertising, and I think the courts are going to throw that case out at the end of the day. The problem is that the companies are going to have to go through the costs of litigation, discovery process, and all that. So where are we? The Supreme Court has recognized the constitutional right to firearms. And Scalia, when he wrote the Heller decision, says this doesn't impact laws imposing conditions and qualifications upon firearms. So there is a Second Amendment right, but even Scalia conceded that there's going to be conditions and qualifications in terms of who can own and who can possess and who can use. And with due respect, I submit that's where this fight should be had. It is a societal issue. It is one for our elected officials. It is one for our legislatures. And it's a mistake, in my view, to try to govern a product through the civil litigation system. It has an impact on other products. Alcohol manufacturers are at risk by the theories that are being proposed in some of these cases. Automobile manufacturers could be subject to liability. Even cities that have sanctuary cities are at risk of getting sued if an illegal commits a crime after being released or not taken into custody. The fact is, theories of tort liability simply are not the way to resolve societal issues with firearms, and concepts of duty and proximate cause are what are going to decide this. And in the long run, from a lawsuit standpoint, that's not the way to resolve distribution of firearm issues in the United States.
Please join me in thanking the panelists. Those were really fantastic presentations, diverse views and substantive questions raised. But since we've got a few minutes left, I wanted to open it up for questions from the audience. Henry Schaefer.
I got a question for Professor Franks. I consider myself an advocate of free and open markets, but I don't like trusts and cartels, and have been very happy with a lot of the laws against price fixing and the like. Am I not an advocate of free markets?
Well, I certainly couldn't speak to your personal view on markets, but I think the larger point is that there's a selective concern about trusts and cartels that's coming from the subject that I was mentioning in my presentation, which is the larger conservative backlash against policy choices made by certain corporations or private actors. And my point being that there is a certain kind of sudden concern about anti-competitiveness that is only applied when it comes to policy changes that conservatives are not fond of.
So I'll hand over here. Yeah, that's you. Sorry. Yes.
So as a non-American, I just want to express my views. It's completely incomprehensible for me that a government can protect an individual's freedom, such as the right to own a fire gun, over public safety. It's completely unbelievable for me. I'm originally from Turkey, and the first thing we learn in constitutional law is that where an individual's fundamental rights and freedoms ends, another's begins. So I really cannot comprehend how the government doesn't uphold public safety over an individual freedom.
I'd like to respond to that. I live in a part of the country where there's a very different understanding about the role of private firearms ownership than there is in many places in the north or in more liberal cities. And the fact of the matter is that many people look at the news every night and they watch places like Syria and Afghanistan and Iraq, and they see countries where the government has basically tyrannized the people militarily. And one of the reasons that they think that among all the terrible problems America has suffered from, slavery and inequality and abuse of industrial labor, the one thing that we've never actually suffered from generally is the tyranny of the government. That is a government takeover of that sort, and many people attribute that to the private widespread ownership of firearms. And the Second Amendment has a particularly privileged place in American culture because of that type of narrative. Now, you may not share the narrative, but it shouldn't be incomprehensible to you because that's the narrative that many people think about. I think on the other side, there's a narrative that Kal pointed to, this idea that it's just not the job of courts to deal in public policy or protect health and safety. The job of courts is to resolve disputes, and that's something that we learn early on in law school. And I would say, actually, that's a terrible myth that's propagated in first-year law school. Liability exposure is a key feature of regulating health and safety in the United States, and it always has been. I can think of at least 6 quick examples. One is auto safety, which lives alongside traffic laws, premises liability, which lives alongside building codes, environmental law, which lives along environmental statutes, products liability and product safety codes, child protection lawsuits and the laws and private policies that protect our children in institutions, and food safety lawsuits and the FDA. Essentially, we've always had liability exposure in our system. It's always been a motivator for health and safety within private corporations and private entities, and it's always been a complement to government regulation. And it hasn't worked out that way in lawsuits against the gun industry, like the examples I mentioned, but part of the reason is because Congress doesn't want to see whether it will. And so I think there are good reasons to reject these suits, and I think proximate cause, which you mentioned, is probably one of the strongest, which is there's a link missing in most of these claims. But I'm not sure the broad argument that it's not the job of courts to be involved in public health and safety is really consistent with the way our system works.
And let me just add, the courts have always looked at design issues and manufacturing issues and whatnot. But the broader question of how should guns be distributed and whatnot, that is a question of public safety, which our legislatures, our states and federal government are responsible. They have enacted, we have bodies that are responsible for putting forth regulations and whatnot. And those are the entities that have the responsibility to ensure the public safety.
So we somehow went to an hour just like that, and I know there are more questions. Hopefully our speakers will stick around for a few minutes if you want to come up and ask them, but please join me again in thanking them.